If anybody is in the back, not seated, could you try to sit yourself away from the door so that people coming in late can kind of filter into the back parts? Much appreciated. Welcome everybody. Hatem Bazian and Maude, for those of you observing. I'm Hatem Bazian, associate professor in upheld, and this is the third event in our teaching series. Let's talk about Palestine. This series is coordinated by the Department of Middle Eastern Languages and Cultures and co-sponsored by the Department of Ethnic Studies, the Department of Rhetoric, the Program in Critical Theory, International Consortium of Critical Theory Programs, and the Center for Middle Eastern Studies. Today's event is being live streamed on our departmental Facebook page and YouTube channel at UCB MELC. And the recordings of this event, the recordings of previous and following events will all be posted to YouTube after they are complete. So we have one more event in this series, which we invite you to join us for. That's at 4 p.m. in this room on April 16th with Ahmed and Stefania Rodolfo, who will present on Palestinian literature and the writing of trauma, with a conversation moderated by Wadie Said. Today's event is titled On Apartheid, Occupation and the Law, and features Drs. Wadie Said, Samera Esmeir, and moderation by Hatem Bazian. I'll just make some quick introductions and then we'll move on to it. Dr. Wadie Said is professor of law at the University of Colorado Law School, where he teaches classes in criminal law and procedure. He is the author of Crimes of Terror, a study of American criminal prosecutions and terrorism-related crimes. He's a member of the American Law Institute and a former federal public defender. Dr. Samera Esmeir is associate professor in the Department of Rhetoric here at UC Berkeley. She's the author of Juridical Humanity, Colonial History, and is currently completing a book on Palestine's revolutions during the 19th and 20th centuries. And Dr. Hatem Bazian is a lecturer in the Departments of Middle Eastern Languages and Cultures and Ethnic Studies here at UC Berkeley, and co-founder of Zaytuna College and the leading scholar in the Islamophobia studies field. So without further ado, please help me welcome our speakers.
Thank you very much. I probably don't need this, as you'll tell. I have a pretty booming voice, but I guess.
You can take it on,
Okay. All right, well, thank you very much, all of you, for being here, and thank you very much to the Department of Middle Eastern Languages and Cultures here for the invitation, and for listening to this talk, in which I've decided to try and tackle a relatively sedate topic, the concept of resistance, both unarmed and armed, in the Palestinian struggle from the perspective of American law, with some reference to international law and Israeli domestic law. So throughout the review of the topic of Palestinian resistance to Israeli occupation, we see three dynamics, right? One is an effective rejection of the legitimacy or legality of Palestinian resistance in the American and relatedly Israeli view. Two, the large overlap between American and Israeli interests as nation states primarily in this regard. And then three, a record of Israeli impunity for the use of force to quell this resistance. And I'm going to be looking at it particularly from, as I said, the view of American law, which would be a discussion primarily of cases from that have been filed in American courts over the years, particularly the last, say, 20, 25 years. All right, but first, a story. Many years ago, I was a public defender working on a large terrorism trial involving the defendants being charged with basically being active on behalf of the Islamic Jihad movement in Palestine a designated foreign terrorist organization here in the United States. There we confronted a RICO conspiracy charge, and I won't bore you with all the details of that. But that is a charge that's a law that was passed in 1968 to help the federal government go after the mafia. And in the way it works is that it basically talks about a RICO enterprise, in this case, the Palestinian Islamic Jihad, a terrorist organization. And if proven, all the acts of the group can be ascribed to the defendants in the case, regardless of whether they actually carried them out or not. So what I noticed is that some of the predicate acts that the Islamic Jihad in Palestine was charged with or accused of committing involved acts on Israeli soldiers in the occupied West Bank and Gaza Strip. So I made a motion to the court. I said, surely these can't be considered criminal acts the way attacks on civilians are, or the way attacks outside of occupied territory. After all, the first additional protocol for the Geneva Convention of 1977 allows for armed struggle against colonial domination. The court's response was swift and unequivocal. The United States did not accept the principle from the first additional protocol for the Geneva Convention of 1977. So the only way a non-state actor can be allowed to use force is if they meet something called the lawful combatants. What does that mean? It means that the group has to carry arms openly, wear a uniform or insignia, operate according to a recognized chain of command, and then finally operate according to the international law of war. So basically, a guerrilla army, a non-state actor, clandestine organization, call it a terrorist group if you like, can never meet those conditions. Okay? So the motion was denied. Even if it could, by the way, American law prejudges this issue by declaring all Palestinian groups that engage in armed action against the Israeli military to be foreign terrorist organizations. As a result of that, the provision of something called material support is prohibited. It's criminally prohibited. It's punished by 20 years in prison. And I've written a lot and talked a lot about that. I'll maybe skip that for now, but I'm happy to talk about it, maybe a question. But the prohibition of providing material support to a foreign terrorist organization, it doesn't depend on your point of view or on the role of the United States. For example, in one of the first cases after this law was passed in 1996, or the case in 1998, 11 years ago, who was caught leaving Detroit International Airport with a bunch of night vision goggles and other stuff. And they said, where are you going? He said, I'm going to Lebanon. Why are you taking night vision goggles and other types of material? You're not going to give it to Hezbollah, which is a foreign terrorist organization. And he said, well, I'm from that part of Lebanon. It's occupied by the Israelis. Isn't that legitimate resistance? And so when they let him go, I don't understand exactly what happened, but they let him go, and then they charged him with material support. So his statement of I'm living in this country and I want to be active in supporting a resistance against, by all accounts, the Israeli occupation of Lebanon is illegal, right? Internationally illegal occupation. That would be that By the way, just in case you thought that the terrorists that was labeled only applied to groups named as such in the foreign terrorist organization context, American law is multifaceted and quite wide-ranging. So, and it works in several ways. So one of them is there's a group called the Palestine Liberation, which is not listed as a foreign terrorist organization for material support purposes, but it is considered a terrorist organization for immigration. So no one who's a member of the PLO can come to this country. unless, of course, they get a special exemption, so the Palestinian authorities have anything else he ever wants to come here, and he has everything to do. And then Yasser Arafat came here and he was the head of the PLO. They had to get a special waiver to come to this country. So if armed resistance is out, what about peaceful? Okay. Well, the answers have come in various cases. So it's a kind of a subtle shift, but I think it's worth noting. While the resistance itself is not subject to criminal sanction, there is no accountability for Israeli state violence that meets that resistance. Okay, so American courts effectively reviewed that position. So in 2003, you may remember the case of American citizen and activist Rachel Horton, who tried to block an armed D9 bulldozer, which is a truly infernal machine, by the way, manufactured in this country by the Caterpillar Corporation. The purpose is to literally destroy structures in the past. So Rachel Horton tried to block the D9 bulldozer from destroying a Palestinian pharmacist's home in Rafah, in the southern part of the Gaza Strip, much in the news before. So she was killed when the bulldozer ran her and crushed her. So her family filed a lawsuit against Caterpillar in the United States. They also would have been run over by D9 bulldozers. But that lawsuit was dismissed. And that ruling was upheld by the Federal Court of Appeals here in San Francisco, Federal Court of Appeals for the Ninth Circuit here in San Francisco. In fact, incidentally, just as a side note, I bet you didn't know that the current dean of UC Berkeley Law School, Berkeley, actually represented the support of this lawsuit, Rachel in this lawsuit. But it was dismissed. How come? Well, the decision to supply the Israeli military with armored bulldozers is a political question, right, that courts have no basis to question. Those decisions are made by the executive branch. Like you maybe saw, there was a case filed a few months ago in federal district court here in San Francisco about the American support of the genocide in the Gaza Strip, and that was dismissed on the same ground. This is a political question. Courts don't have any jurisdiction. Another instance of a U.S. citizen engaging in sort of peaceful or nonviolent resistance to the Israeli occupation, in this case the siege of Gaza, came during the May 2010 flotilla incident, you might remember, where a dual there was a flotilla of ships carrying aid and activists that turned to break the complete blockade of the Gaza Strip. So they attempted, the activists attempted to have a bunch of ships land on the port in Gaza City. Furkan Doga was a hundreds of people killed against one person, etc. This all began with the Apartheid case, which was it wasn't just a kind of a spur of the moment decision, it was based on a policy. But how many non-combatant, innocent, collateral damage type victims are acceptable when the Israeli military decides to go after what they call terrorism, what they do with identify as terrorism. So on the American front, two developments. First is the victims of the families of the victims of this attack. Two, the making this type of calculus, who's the target, how dangerous are they, how many other people are us. And we've seen how that, again, in the last 5 months plus, how that calculus has kind of strained all along, all morality. Anyway, that policy, amazingly, made its way here. How do we know this? Well, you may remember in 2011, the U.S. citizen by the name of Hatem Bazian was killed by the United States in a drone attack while in Yemen, its country war. And what we learned was that it actually took a while. It was kind of a roundabout situation where another Harvard law professor who was serving a guy by the name of Bazian was up for a federal judgeship in the First Circuit in Boston. And so during the hearings on his nomination, it surfaced that he had written a memo about he would have the Office for Legal Counsel, the main arm that interprets the law and Constitution according to the rulemaking body for the Department of Rhetoric. He was the head of that. And when he was the head of that, he issued a memo basically saying why it was okay for the United States to allow the U.S. citizens to know no process at all. And it turned out that he had relied a lot on the Israeli law, and his law was highly colonial extrajudicial killing. So it was cited, this policy, this Israeli policy, cited by the United States in a positive way, so as a sort of well-reasoned way that this country can challenge assassination. Anyway, returning and kind of wrapping up here. Currently, as we see in this country, attempts at peaceful resistance are not faring so well on the judicial front. You may know that 38 states have anti-US law, okay? Which is, it still boggles my mind because there's a 1982 Supreme Court case called Essentially essentially recognized as the right political. But that hasn't stopped states from passing the law. And the latest iteration of these types of litigation in last year, the full court of the eighth federal appeals court, so Minnesota. But the Eighth Circuit actually upheld Arkansas's anti-BDS law on the basis that it's essentially economic activity and not speech activity, and it's not affected by the First Amendment, which of course renders a lot of the First Amendment leads to kind of meaningless. So we're going to have to see what ultimately shakes out with the anti-BDS law. But there's certainly a very strong message from our collective government, state government, not just federal government, that peaceful resistance is still also, unfortunately, we're both. And I'll stop there. Well, after that, I'm sure uplifting picture. But at least we know what the lay of the land is here, the lay of the law, and how it has impacted what we see.
Thank you, everyone, and thank you for the organizers and for everyone for being here today. We're continuing to make Palestine present in this campus and for participating in this meeting project. Even though this is a talk about law and talk about apartheid, I want to begin by marking our response. This is the time of obliteration, Israel's obliteration of the Palestinians, the land, the earth underneath them, and the skies above them. By obliteration, I do not only mean the killing of tens of thousands, the injury of hundreds of thousands, no. I also do not only mean the starvation of the already hungry and the intervention of the yet to be determined many Muslims. Neither is the obliteration limited to the destruction of the infrastructure of life. All of this is certainly in play, but to focus on the destruction of life alone is to reduce the Palestinians to their biological existence, which is precisely what Israel is attempting to do. By killing and maiming Palestinians, Israel extends the machinery of obliteration to other surviving Palestinians in the work to limit their lives, cling their lives to the fear of death, disease, or starvation. Killing, maiming, starving aim to coerce Palestinians into submitting to their physiological existence and setting aside their collective, resistant sociality on the land. It is the latter, the collective and resistant sociality on the land, that is the target of Israel's obliteration mission. Genocide, in the ground, is its means, or an episode in a larger obliterating project. Genocide simultaneously eliminates. In my views, therefore, obliteration, Israel ruling of the land, not making it, severing the relationship between the land and displaced Palestinians, and consequently eradicating the protections that the land has offered them, they, the stateless colonized subjects in this world. By uprooting them, turning the land uninhabitable, and banishing the uprooted to temporary structures, obliteration aims to dismember the land and its people. The goal of the project of transforming the Palestinians who remain on the land into roaming figures, evacuated of their souls, with no grounds in the world. Obliteration, in short, aimed to produce the Palestinians as less of the world. From a colonial perspective, the encamped Palestinians in Gaza are a model for the rest of the Palestinians on the land, suffocated, cramped, reduced to their basic needs, and lacking in permanence and variety. All Palestinians have been subjected to the destructive powers of this model, but Palestinians in Gaza today are forced to pay the heaviest of prices in the project that aims to reassert and radicalize paths of obliteration. To be sure, the time of obliteration is not only our present time or of our present, is made of our present time. Even after a ceasefire is established, and notwithstanding all talk about quote unquote the day after, which presumes an after that is distinct from the before, there will be and will have been obliteration. Even when this genocide runs its course, it will have happened. Obliteration is not an event with a limited duration that you can mark on a calendar. In a settler colony, obliteration neither begins nor ends. Instead, it slows down and accelerates, moves to the background and returns to the center, fades and recurs. In Palestine, obliteration stretches decades back to 1948, when more than 400 villages were destroyed, 85% of the Palestinians expelled from the earth beneath them, and many were killed along the way. Obliteration also stretches back to the failed Zionist and British attempts decades earlier to engender mass colonization of the land during the Mandate period. In Gaza today, obliteration reaches into the future. By targeting children, the figures who extend any collectivity into the future is diminished. By destroying homes and sites where permanence is fabricated, ongoing fleetingness is reinstituted. By wiping out the durable structures of the past, the material conditions of inheriting a past and passing it on melt into thin air. My talk today concerns these times of obliteration and the legal order that sustains them. But before I continue, I want to introduce an important caveat. Ours is not only the time of obliteration. It is also the time of wreckage. It is the time of rubble that is yet to be removed. It also may not be removed, and we don't know if it could be said to have ever been removed following earlier rounds of destruction. If obliteration aims to wipe out a place, remove all traces, and start from scratch, rubble, wreckage, disfigured Palestinians, and dismembered structures mark the limit of obliteration, its impotency. Obliteration, it turns out, can only aspire but not succeed to start from scratch. Disfigured traces haunt the land. Broken, evacuated souls roam it. Even the corpses of the dead stage their grievances. Wreckage, rubble, and lone structures provide grounds for Palestinian sociality, collective existence, and struggle. In short, sites of banishment which are not reduced and resist the colonial obliterating machinery. This is then also the time of resistance. I will return to this refusal and resistance at the end of my talk, but for now, I want to stay with the time of obliteration, the laws of obliteration, and the question of apartheid. To raise the question of apartheid today, as Israel's legal regime with which it is said to have governed Palestinians, requires rethinking. This rethinking is necessitated by the present intensification of obliteration. That's why I started with it. It is also necessitated by the history of apartheid in South Africa. There, the primary preoccupation was not how to obliterate, but how to govern. Arguably, the current genocide in Palestine is the necropolitical limit of an otherwise apartheid state,
an exception, or maybe an addition to it. Therefore, it is often said Israel is an apartheid state, but worse. However, such a conclusion steps over the inquiry into the relationship between genocide, obliteration, and apartheid, between an order that destroys and eliminates and another that attempts to govern. Is an obliterating state reconcilable with an apartheid state? To answer this question, we ought perhaps to allow this devastating moment to disorient us and even guide us. Otherwise, it is as though we have not learned anything, as though Palestinians in Gaza have not undergone anything, as though we have not witnessed from afar the destruction of their lives and the earth on which they live, and as though the day after is indeed a distinct day after obliteration, just as October 6th was the day before. I want to convey the following argument in more detail in the remaining part of my talk, but I'll just sum it up now. Obliteration, not apartheid, constitutes the primary technology of Israel's rule over Palestinians. Apartheid is secondary to obliteration. It is one of its means. Israel has failed to commit to apartheid as a comprehensive technology of government. Not because it has yet to slip into apartheid, but because it has yet to progress beyond obliteration. Still, apartheid is operative in Israel. It is the legal regime active in the break, if you will, between different rounds of destruction. Propelled in the intervals of destruction, apartheid legalities stabilize the result of earlier destructions and anticipate and prepare the ground for further destruction. Along the way, apartheid legalities imbue the Zionist state, and this is crucial, with a legal order that is not pure destruction. Apartheid legalities say that. To see beyond the facade, then, requires seeing the background of obliteration as the front. To see beyond the facade requires seeing the background of obliteration as the front of apartheid. It's the background of apartheid. So apartheid is the front and obliteration is the back. This view has consequences for the kind of struggle Palestinians have been waging. If the struggle against apartheid may conclude with equal rights within an apartheid state, it is less clear that such legal redress can contend with obliteration. In what sense is equality an answer to obliteration? Allow me to unpack this argument more. I repeat, obliteration, not apartheid, constitutes the primary technology of Israel's rule over Palestine. Israel's massive imperial entanglements, participation in the military-industrial complex, and mobilization of industrial violence and surveillance technologies make for a 21st century settler-colonial power that is less interested in governing the colonized Palestinians and more in removing them from the land or enclosing them in little stretches of land from which they cannot leave without the self-declared masters of it. The unfolding genocide in Gaza also reveals that Israel wishes not to govern. Consider Benjamin Netanyahu's plan for the day after. A document consisting of a mere page and few lines in Hebrew. It responds to the question preoccupying think tanks, international actors, and diplomats. Who will govern Gaza in the day after? Netanyahu's brief document does not pertain to answering the question of government. Instead, it declares that Israel will secure its freedom of operation across the entire Gaza Strip, create a security zone, control the border with Egypt, demilitarize the Strip, obviously Palestinian militarism, Israeli militarism, and de-radicalize the population with the assistance of Arab states that have similar experience in Saudi and the Emirates. There is a vague reference to reconstruction and a fleeting reference to government. Local elements with management experience will be assigned the task of management, who are not affiliated with entities that support terrorism. They will be responsible for civilian management and public order. A very thin understanding of government. That's it. There is no desire to govern, only to militarize and securitize. Some commentators, as most of you must know, suggest that Netanyahu kept the door open for the West Bank Palestinian Authority to govern. In the terms I have been discussing, this would entail creating a new Gaza Bantustan to stabilize the outcome of obliteration. But we could also say that the absence of a plan to govern tells of Israel's failure as a colonizing state. It may also tell of Netanyahu's conviction that there are no Palestinians to be governed, only to be obliterated. One may ridicule the plan, Netanyahu's plan for the day after, but is it so exceptional? Or has its rationality been with us for decades, albeit in different forms? Let us return back in time and recall something that, fact that most of us in this room will know. That on the eve of the proclamation of the State of Israel, 88 to 91% of the cultivable land was neither owned nor leased by Jews. It took the 1948 war and the removal of the Palestinians en masse to enable the total Zionist appropriation of the land and its mass colonization. Zionist settler-colonial mass removal of the Palestinians was first carried out militarily, as we know, in 1948. And then, in the words of Israel's second prime minister, he described it as a wholesale evacuation, which was, quote unquote, more wonderful than the creation of the Jewish state. Removing Palestinians and wiping out the land of its people was a necessary condition for Zionist land occupation. Removal enabled starting from scratch, or the fantasy. But for so long that there remained Palestinians in the shadows of Israel's borders, in the camps, along the borders, starting from scratch was indeed fantasy. Israel would have to introduce other military, policing, and legal measures to prevent the return of the removed and stabilize the result of the 1948 occupation. And this is when the law begins to act. A key measure was the border police, which combated the return of the refugees to land by either killing them or removing them again. Another was the Transfer Committee, which initiated the expulsion of Palestinians from Israel in the aftermath of the war. Other measures targeted the land itself. Appropriated by the new state, the land's nature was destroyed, landscaped, and Judaized. The construction of the border settlements aimed to secure the land's transformation into Israel's territory. The removal of the Palestinians living in the conquered land and the ban on their return were the means by which the territory of the Jewish state was fabricated out of appropriated Palestinian land. Starting from scratch, drawing a line, and localizing the new Jewish state on the surface of the earth was first and foremost the work of obliteration, of wiping out. Many laws would follow to stabilize this wiping out. Emergency regulations, absentees' properties, and requisitions of property regulations, and the infamous, of course, the famous absentee property law of 1950. As to the minority of Palestinians who managed to remain within the borders of the newly sanctioned settler colony, internationally sanctioned settler colony, many were forcibly displaced from their homes, villages, and lands. They became, quote unquote, internally displaced, never to return to their homes and towns. Banned from spreading out, they endured shrunken, suffocating existence. The two-decade military regime imposed on them and its routines of inhibition in the form of permits, zoning, and planning schemes, as well as the restrictions on movement, the legal restrictions on movement, secured their tamed, spatialized existence. As a result, only 3% of the land would remain in Palestinian hands. 93% of the land would come to be owned directly by the state via different agencies. The war of conquest, along with the legal measures that followed, extended to the productive annihilation of Palestinian inhabitation of the land by transforming it into an empty territory for incoming settler citizens of the new state. Once the people were obliterated from the land, once the land was obliterated from its people, legal forms solidified the results of obliteration. The state would continue to materialize itself as Jewish. The refugees on camps on the other side of the border who attempted to return would be classified as infiltrators. The Palestinians who managed to remain within the new state's boundaries and became citizens of the new state were renamed as Israel's Arabs. In fact, the English Israeli Arab doesn't capture the possessive relationship that the Hebrew articulates, Israel's Arabs. If the obliteration rationality dictated that there would be no Palestinians left on the land, their existence had to be consciously misrecognized. Hence, Israel could tell itself that there were no Palestinians on the land, only Arabs. Identity cards and an entire legal apparatus established and maintained this legal fiction. The description Jewish state is an elaboration of this obliterating fiction. Of course, life is always more complex than the colonizers' plot. There was obedience and compliance, yes, but also refusals, revolts, and protests. Palestinians did not abide by the calendar of obliteration. The project itself had cracks and failures, hence the necessity of law again and again. The powers of law, especially positivist state law in a colonial state, are many. However, one of its critical operation is really crucial, and it's for the most part often neglected. Legal regulation stabilizes. Because the temporality of positive top state legal regulation and codification is presentist, in the sense that it cares not about history or the future, but about regulating the present, the legal form became a forceful technology for stabilizing conquest and obliteration. State law regulates the is, not the was and what will be. Legal regulation is also never about the why. It is technical. This presentism of Israeli state law renders it suitable to fill in the breaks between rounds of destruction and to stabilize their consequences. However, the law was not the only medium that stabilized the outcome of the 1948 obliteration or Nakba. There had to be more obliterating campaigns. Such was, of course, the 1967 war. The 1967 war is often understood as extending Israel's control over the territories that it occupied. But what is frequently missed is that the 1964 war stabilized the Zionist conquest of 1948. That the West Bank and Gaza became, quote unquote, the occupied territories meant that there were no other occupied territories. Occupation became external to the Israeli state. The war, in other words, set in stone Israel's territory, which is to say, stabilize the results of obliteration, the 1948 one. But there was more. The so-called occupied territories would become the terrain for unleashing Israel's military power, thereby preventing the next rounds of destruction from intruding into the already obliterated land, into the space of legalized normalcy, Israel. There, behind the green line, Israel would conduct its war against the Palestinians. This much is more than evident today in Gaza. And the story continues. We could recount many more rounds of destruction, some more extreme than others. We could continue to map out Israel's legal system as one that is intertwined with these rounds of destruction, filling in the breaks between them, taking on some of their tasks, and stabilizing Palestinian enclosures from the river to the sea. In the Galilee, where Palestinian villages are suffocated as an effect of Israel's master plan. In the West Bank, where you cannot leave a town or a city without crossing a checkpoint or reaching a settler highway. Or in Gaza, where the blockade became a way to remove Palestinians from view. It is this spatial order and the legal regime that facilitates it that endows Israel with the title apartheid state. Next to the spatial order, some additional laws discriminate, dispossess, and dominate, and you can check many reports about that. The spatially visible system that had led several international organizations, including, as is well known, Amnesty International, to declare Israel an apartheid state. Amnesty's report points to the massive seizures of land and property, unlawful killing, forcible transfer, drastic movement restrictions, and the denial of nationality and citizenship to Palestinians. Refusing to locate apartheid only in the West Bank and Gaza, Amnesty's international report details how Israel enforces a system of oppression and domination against the Palestinian people everywhere, including outside the borders. In this invocation of apartheid, in the many reports also written by Palestinian group, it was the legal definition of apartheid, not the historical South African version of it, that was deployed. The definition is available in the International Convention on the Suppression and Punishment of the Crime of Apartheid. We may therefore read these reports as articulating a new version of apartheid that exceeds the South African itinerary. Such a reading is indeed possible, but one could also argue, and I'm going to share three possible readings, one could also argue that Israel is yet to become an apartheid state. As I said, not because it has yet to deteriorate, but because it has yet to progress away from obliteration. Israel, in other words, has had detours into apartheid, including through the Oslo Accords, which is to say the peace process was an apartheid process. But it has failed over and again to commit to apartheid as a comprehensive technology of government. It has failed to be content with the powers of racial and racist supremacist separation. The current genocide in Gaza is one instance of such failure. However, there is another possible argument that I have been tracking in my talk. Might it be that apartheid legalities and spatial orders are the presence that hides the absence of the obliterated? If so, then Israel's apartheid is secondary to its project of obliteration. Apartheid occupies the time in the break between different rounds of destruction. It occurs in the intervals of destruction. It is also what stabilizes the results of destruction. That is why it is most visible, even though it is not the primary technology of Zionist rule. The apartheid legal regime is also what enables future rounds of destruction. By segregating a population, its removal or killing becomes more possible. Such was one of the objectives of the refugee camps after 1948. Placing the Palestinians in refugee camps allowed for their future collective removal. This too is what we have been witnessing in Gaza. And here we must recall a somewhat neglected article in the Apartheid Convention, one that connects apartheid to genocide. Article 2, paragraph 4, defines the crime of apartheid and speaks of deliberate imposition on a racial group or groups of living conditions calculated to cause its or their physical destruction in whole or in part. The resonance with the Genocide Convention is clear. But there is more to apartheid in its relation to obliteration. Paradoxically, apartheid legalities have enabled Israel to normalize itself as a state, albeit racist and criminal. Obliteration and destruction alone do not make for a normalized state. Apartheid does. In this sense, legalized apartheid is that which fills in the time of the state, which would otherwise risk its death if it were to be engaged only in destruction. Apartheid saves the Zionist state from its death. It allows the state to stabilize the results of its destruction of the Palestinians as it prepares for the next one. The time of the state cannot be the time of obliteration forever, but could very well be the time of apartheid. This is also why, even if apartheid is not the principal technology of rule, the anti-apartheid global movement remains a crucial one, and my friend here, Sharad, reminded me of this. But this is also why we must articulate the time of obliteration and implicate apartheid legalities in obliteration. Otherwise, we risk not noting how in its Israeli settler-colonial itinerary, apartheid sustains obliteration and Israel simultaneously. Let me conclude by saying that and I'm returning to the time of the wreckage in conclusion. If this is the time of obliteration, it is also the time of wreckage, rubble, and resistance. The subjects inhabiting the wreckage are not the subjects of rights and democracy. For them, equality is not an argument against obliteration. Legal redress is not an option. It behooves us, therefore, to recognize Palestinians in Gaza, but elsewhere as well, as they live in the intervals of destruction, without permanence, always about to suffer another colonial cruelty. Their world is not of enduring things. Theirs of living, surviving, and regathering their shattered existence from one destruction to another. One could say that the entire liberation struggle of the Palestinians concerns their relationship to the interval, facing colonial destruction from homes to neighborhoods to villages to cities, becoming refugees, getting captured, being killed again and again. In the interval, from the midst of the rubble, refusal of obliteration and resistance against it protect the Palestinians. This is then an invitation to begin to reckon with the danger that Palestinians have been confronting for decades. One they will continue to resist, from the river to the sea, but also to the skies that will return the Palestinians to another world. Thank you.
Two wonderful talks, and I'm gonna have a quick question, but then I'll turn it to you to the audience, so we could have as much questions and interaction. We're gonna be out of here 5:30 sharp, because they need the room. The question I have for Wadie, since many of the students' groups post October 7th have been attacked with material support, especially SJP and others, how does the law in relations to material support will be utilized in this next stage, considering what has taken place in Florida and other places? So material support has been this big, almost sucking machine that has been used predominantly against pro-Palestine activists from the 1988 to the anti-terrorism law of Clinton up to this period. So that's that question. And then for Samera, the concept of obliteration is really a powerful concept. Can we think about the Zionist settler-colonial project is still ongoing, where apartheid usually settler-colonialism ends and moves into governance? So how we would think in terms of the never-ending settler-colonial project in terms of Zionism?
Yes. Okay, thank you for the question, Hatem. In 2010, the Supreme Court, in a case called the Humanitarian Law Project versus Holder, delineated what it meant by material support. And it did say that material support in the form of speech which would normally be protected, can be criminalized as material support. But there was a caveat. The caveat was, so that case was, there were some litigants who wanted to help the Kurdistan Workers' Party, the PKK, and another group of plaintiffs who wanted to help the Liberation Tigers of Tamil Elam, also known as the Tamil Tigers. They wanted to help these groups, but they said, we don't want to help them with violence. We want to help them become more peaceful. So we want to help them petition the US government or the UN for, recognition for their cause. Can we do it? So it wasn't a criminal case. It was a civil lawsuit. And the Supreme Court said, actually, you can't do it. That if you were to do that in coordination with or at the behest of the terrorist organization, that would be material support in the form of material support to a foreign terrorist organization, and that would be prosecutable. Okay, so the key thing there is that it carved out a space for what is known as independent advocacy. So someone, even though I wouldn't suggest it, and I'm not giving legal advice, I'm just sort of speaking out, someone could go out and start chanting support for a foreign terrorist organization. Okay, and even broadcasting, on, however they want to broadcast, ways in which terrorist organizations can lobby Congress or do whatever it is, whatever expert advice, that's the technical term, whatever expert advice or service they want to give, as long as it's done independently, so not with the group. Now, the problem is that area of the law is, as one court noted, unelaborated, right? There isn't like a long list of these cases. There's only one case that I know of where the court in an awful decision called United States versus Mahenna, but it was a guy who was charged with operating or doing some translations that he posted online, and the government said he did that on behalf of Al-Qaeda, which is a foreign terrorist organization in the United States. And his point was that he just did this as a kind of a journalistic or some sort of other service, and that he wasn't working with the group. And the government's evidence showing a link between him and members of the FTO of Al-Qaeda were pretty weak, but that didn't convince a jury, and he was convicted, and then the Court of Appeals upheld his conviction. So while I would say that the independent advocacy is an important check, when the ADL and the Brandeis Center made their intervention in this matter, right? They know that the FBI can open these types of investigations on very low, there's a very low evidentiary threshold. So as a potential harassment tactic, it's very, 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 I think, significant and dangerous, right? Will it lead to prosecutions? I mean, I'm not like the world's expert on this topic, but I do know a little bit. And I would say like the number of students active on behalf of, say, the Islamic resistance movement, Hamas, I don't think there are that many, if at all. But that hasn't stopped. I mean, the material support law itself was passed on a dubious evidentiary basis. So I don't think we should just take that at face value.
Well, that's why also to speak about Palestinian resistance becomes less possible in the US. And I think Wadie's presentation explained that, outside even the legal form. Yes, no, absolutely. But I think, Hatem, and the question is about settler colonialism that continues. But I think, you may remember more than I do, but just because I didn't live through that period. It seems to me that apartheid framework becomes much more present after the Oslo Accords, which then feel like as if Israel is moving from the settler colonial to the apartheid, right? So the peace process was an apartheid move,
right? So it would have ruptured the settler-colonial, except of course it didn't work this way at all, and it ended up just intensifying the settler-colonial in a way that is distinct. But it might have been sort of the South African, it could have been the South African transition to apartheid.
So let's take questions. Just raise your hand. And Tim?
Following up on Hatem's question about giving material support to the foreign terrorist organizations, I noticed the last time I looked, what objective criteria does the State Department use to list people and unlist people? The last time I checked, they still had the official Popular Front and Democratic Front on the list, but for some reason they've taken off one of the Democratic Front split-offs. And I forget the name of which one. But what criteria do they?
Yeah, I think they got rid of the Democratic Front a while ago. Yeah, but they do have the Popular Front, has been there for a while, and the Popular Front for the Liberation of Palestine General Command, if you follow these things. So, yes, so this is again a tortured issue because we're running kind of headlong into these political decisions that are not what the courts call justiciable, right? They're not subject to litigation. So basically the criteria is the group is foreign, the group carries out terrorist activity or violence that it should know is terrorist activity, and that terrorist activity impacts the national security of the United States or the national security interests of the United States, which could be, foreign relations. The PKK is there because this government historically has been a strong ally of the government of Turkey, which has, in recent years come under some strain. But, same thing with the Sri Lankan example. So people have tried to argue, right, because the group itself is listed, but an individual is charged criminally, because in our system, criminal liability is individual. But an individual can be charged with providing material support. They can't argue the validity of the designation in any criminal prosecution. And in fact, it can't even, a representative of the group can't even argue the basis for the designation, because that's a political designation. That's a political decision that courts have no business getting involved in, according to the courts themselves, when people have tried to do it. And the final point on this is that, the only way that the government can kind of be stopped is if they make like some sort of technical error. So, they put the wrong, they designate the Popular Front. They designate the People's Front when they meant to designate the Popular Front. Literally, it's that level of kind of a technical or clerical error. Because, this is, and when the groups get taken off, again, is equally opaque. So I think it was in 2022, miraculously, the Kahana movement, which had been listed a terrorist organization for 25 years, from the beginning of the list, 1997 to 2022, just disappeared. The Kahana people didn't disappear. They just went and just created new groups. One of them is the national security minister of the Israeli state. And you've seen him much in the news, this fellow Ben-Gvir. He's a Kahanist. He says it openly. But he just changed the name. I mean, could you imagine Ismail Haniyeh or, whomever? Could you imagine Yahya Sinwar one day shows up and says, you know what, I'm actually not in Hamas anymore. I'm in the Islamic Front. He couldn't do it. But amazingly, these people have been allowed to reconstitute under the thinnest of figures of fronts or facades, and they've managed to get away with it. Yeah, sorry, I once made a motion about that in court, and I lost many times. I'm still bitter, as you can tell, even though it's almost 20 years later.
Anyone else? Still have some time, so.
Thanks. I'll try to ask my question loudly, I guess. I want to ask about maybe the origins of the term extrajudicial, because it also seems that we use it in a way that doesn't really make sense anymore, because some of the cases that were discussed are or have become judicial. But I just wanted to see if we get a bit of an overview of the trajectory of that term and if it really actually helps us understand the current events anymore.
Yeah, take it. It's your.
No.
This is for you.
All right, it's for me. All right. I guess I'll take, what's that?
I thought this was for you.
Okay,
Yeah.
that's nice of you.
I mean, I can.
Yeah, well, I
Not my
think,
complicated one,
yeah.
but you go for the legal
I
one.
mean, I think that's a good question in the sense of it highlights how bloodless some of this terminology is, right? And I do think that, yes, I mean, I said it because that's, you know, that's sort of how these things get employed. But yeah, it's more than that. I mean, it's, you know, you could say state-sanctioned murder and say the same thing. So I wasn't, you know, I was just kind of using a type of terminology that's, you know, generally employed. But I'm not stuck on it. You know, it's like administrative detention. If you know what that is, you know, the Israeli military makes use of a tactic called administrative detention, which is to hold people without charge. I mean, it could be, given that we're likely looking at a scenario where the World Court is going to hold the occupation of the West Bank and Gaza and East Jerusalem to be illegal under international law. The idea of taking people and holding them without charge, you know, I mean, we could also call that state-sanctioned kidnapping, right? And so, yes, terminology can play a very instructive role, let's put it that way, in neutral terms, but yes.
But it does still work within a liberal imaginary, right? Like if it works in that argument, in a liberal imaginary, it works. You say it's extrajudicial, which means it doesn't have the legal authorization. But then once you question the legal authorization, as Wadie just did in his presentation, then it ceases to work, right? But that time you've exited the liberal imaginary. And so, but the extrajudicial does work. And if you want to mark the violation of the legal violation in that field, it does. But I don't think it works analytically to then describe the state actions.
So a question for I mean, with the talk, of course, is about the criminalization of Palestinian resistance in America legally. For Samera, in terms of your talk in terms of obliteration, what role does Palestinian resistance have in moving the narrative that you charted about obliteration being the main thrust, apartheid being a holding pattern, and then back to obliteration? What role for Palestinian resistance in moving this one way or the other? I mean, in other words, rather than seeing it only from an Israeli perspective, the way you charted it brilliantly, what role for Palestinian resistance in this narrative?
Right. No, I mean, and I think the entirety of the history of Palestinian resistance is one that recognizes what I've just laid out. And therefore, it's always in response to that. And in this sense, it is one of the ways, for example, in the past it has done that is precisely by violating Israel's territory, because Israel's territory is cemented, is sort of comes into being because of obliteration. So the violation of territory is not any violation between two states and, you enter and a terrorist and so on and so forth. It's actually quite a historically and politically specific violation that responds to obliteration as the process even by which the territory came into being. So the Fidaiyin, for example, in the 60s, that was one of their the entry into the territory and the attacks onto the territory were in response to that. The refugee camps, if we can think of them, the cultivation of resistance, not only armed resistance, but other kind of resistances. I mean, armed resistance is central. I'm not trying to avoid it here. I'm not trying to. But I'm talking about other kind of socialities and collectivities in struggle that are also important. I think what is really important to remember, I mean, to just answer the question even slightly differently, Osama, you might not have that in mind when you're asking me, is that if we take seriously obliteration and apartheid as the holding pattern, as you put it, and it's a nice way of putting it, then we must take seriously the challenges that face the resistance. And therefore, we must seek to understand why is it that the resistance, well, we must then see why is it that the resistance, armed Palestinian resistance, has not been legible. Because of the ways in which it always came to the territory from the outside, Israel's territory from the outside, unless it agreed to conduct the the conflict elsewhere in the West Bank and Gaza, or in Jordan, say, in the 70s. And so that, I think, is important. What is also important is resistance, whether in their revolutionary form, whether in other militant forms, whether in other forms as well, is the means by which one continues to lean to the land that protects them. Resistance is the means by which one continues to lean to the land that protects them, because the land has been transformed into Israel's territory. So it's the means by which the land is maintained. And for stateless people, that's the only thing that protects them. And in this sense, therefore, resistance activates protection and insists on a place in this world. So it is an entirely other story than the obliteration story, but the one that exists in relation to it.
You want to comment on this question? Go ahead. That'll be our last question.
Oh, okay. Thank you. Samera, I wanted to continue a little bit with Osama's question and ask you, in what you described as the temporality of the interval, and in this practice of resistance, and resistance from your answer just now, you could think that resistance itself is of land, right? It's not only a resistance against the Israel state, but it's like being of land is resistance. So I wondered if you could, that is a practice of life also, right? And so in order to kind of also just maybe end on a, for us, a different, I mean, we're all acknowledging and we're all committed to the struggle and acknowledging the genocide, but I wonder if you have some examples about what are some of the practices in those intervals that allow not only for solidarity networks to be drawn, that redraw cartographies imposed by the Israeli state, but that are also practices that offer other horizons and other futurities.
Now, I think they exist all over Palestine in this sense. Some of it is not collective. Some of it is just on how you live your life, how you go about living your life and maintaining a connection. But there are also examples of collective organizing that is of the land, as you say. It's not necessarily aimed for different futurities. It's actually a return story, right? It's aimed to reactivate the past. And the example I will give is one that is sort of very familiar and very personal. I mean, it's not personal, I didn't do it, but it's the people who organized are friends. And as you know, because there were about 400 villages that were destroyed, more than 400 villages that were destroyed in 1948, so you would think 7-8 decades later, people have given up on returning, right? You would think that the progressive calendar of the state has dominated our own calendar. You would think that we just move forward, right? To another place, to a better place, and you just find and settle. And you do, in many ways you do that. But you also do something else. And that something else, for example, there were 2 villages that were destroyed in 1948. The grandchildren of the people who were displaced went back to the village, lived in it. I mean, it's destroyed, it's ruins, it's rubbles. That's why the rubble is important and the ruin is important. It's not just, a free individual roaming and activating free choice and so on and so forth. It's from the conditions of rubble and ruins. Their grandchildren went back in 2013, I believe, or 12, went back and lived there for 1.5 years. Now, and they declared, we are no longer refugees. That was their declaration. Their parents had gone on hunger strike in the 70s in order to return. There were many other, so there is this drive, right, that keeps on repeating. And you don't understand it by any sort of by any temporality of a progressive state. You can only understand it by this attachment. And it's not an attachment that is nostalgic or that there is something about the land. That is that it is actually the place, it is the grounds that offer you a place, that offers you a sense of not belonging, but a sense of existence. And that's why you see this in so many places, those projects of return. They're quite fascinating and important. And again, to remember that the calendar is not the calendar of obliteration, nor is the calendar of the progressive time of the state of move on. It's a different kind of temporality that guides them.
Thank you. Thank you. Please join me in thanking both Samera Esmeir and Dr. Please put April 16th on your calendar, and we'll see you again here on Tuesday. So make sure to put that on your calendar, and we're going to take attendance for those who don't join us again. So thank you, and look forward to see you again.